Welcome to A Conversation With, a podcast that takes you inside the lives of people who've defined the environmental services industry. Join host Scott Davis as he sits down with innovators, entrepreneurs, and leaders to uncover career-shaping moments, personal insights, and the lasting impact they've had on the field. Now, let's join the conversation.
So, Bill, appreciate you coming on the podcast. Thank you for agreeing to do this. This is, there's a list of people I've always wanted to talk to and hear their story, and you're one of them. So, thank you for coming on. So, thank
you for inviting me, and welcome to my home in Northern Virginia.
Yeah. Well, likewise here in Austin, Texas, and obviously Josh is down there in San Marcos. So, you're getting a couple of Texas boys here with you.
Well, I lived in Texas for at least a year. So
where was that?
Dallas, and my first professional job.
Oh, what job?
I was
what job was that?
To a federal judge in Dallas.
Oh, really? Okay, tell me about that.
Well, when I graduated from law school, I applied to a number of federal court clerkships, and I was invited to interview by a district court judge in Dallas named Sarah T. Hughes. She was one of the few women in the federal court system at the time, and her footnote in history is that she swore Lyndon Johnson into office right after President Kennedy's assassination and the swearing in took place on Air Force One.
Wow.
It's the second most famous photograph of the 20th century after the raising of the flag in Iwo Jima.
Oh, really? Okay. That's interesting. So
I have one of two photographs autographed by both the judge and by President Johnson.
Oh, wow. That is neat. That is so have you ever spoke to Larry Snaff about this? You know, he's a big JFK guy, conspiracy guy.
No, I mean, I know Larry very well. We've talked about a lot of things, but not my career or really his career either.
Oh, wow. So I would love to be there when getting you guys together to have just to talk about that, tell him about your history, because he has been fascinated with, the JFK's assassination and so forth like that. And it would just be interesting to see you guys talk about it. So, or just the fact that you have that picture of the swearing in and all that, that's pretty cool. Yeah. Well, good. So you did that job for a year in Dallas. So what is that? I don't know much about what that entails, being a clerk like that.
One of the great honors that law graduates can get is to work for a judge for a year. The title of the job is law clerk, but the reality is basically a research assistant.
Okay.
And I worked for her for a year. It was a great opportunity. Remember, this was 2 years after the assassination. And she was, extremely well known. It was not only trial experience in the courtroom, but in those days, the appellate court, the Court of Appeals for the Fifth Circuit, was very short-manned. And so a lot of the district judges were asked to help out by filling the three-judge panels.
Okay.
So I had a 2-week stretch of being a law clerk for a Fifth Circuit Court of Appeals panel of some of the greatest judges of that era. At that time, I remember meeting a law clerk to Judge John Minor Wisdom, who just went on to great fame. It was Lamar Alexander, who became a U.S. Senator from Tennessee.
Okay. So is that a paid position? Is it?
Absolutely.
Okay.
Now, it wasn't very highly paid. Today, it would get you nowhere. I was hired at $6,000 a year, but when I passed the bar, the judge raised my salary to $6,800.
Wow. That's a little
But
bit,
I didn't get rich that year.
yeah. It almost sounds like you're working in the agriculture business because I think they can pay below minimum wage. So I
Well,
worked for a rancher and grad school.
the experience is invaluable,
Wow.
and the contacts you make are invaluable too, because from there I went to Washington D.C., and of course I've been in this area now ever since. But I was hired by the Justice Department to work there, and the uh, one of the people who was kind of the recruiting process had previously been the U.S. attorney in Dallas. So I must have gotten a pretty good recommendation from the judge I've worked for because I got hired there.
Was that the antitrust division?
Well, I did go to the antitrust division. That was not my first choice, by the way. But the way it worked is that whichever division makes you an offer, it blocks the others from competing for you. So I had to either say yes or no and then take my chances. But I ended up saying yes. And it was the smartest thing I ever did. And you could tell that it wasn't smart because I knew, but it was probably the best um, part of the Justice Department to get experience that will get you ultimately into a good private law practice.
Okay. Yeah. So have you always wanted to be a lawyer?
Probably not. Um, I was actually interested in music.
Okay.
And I went to remember I grew up in New York City, so that's where I was born and raised. And I went to a music-oriented high school, which was a magnet school called in those days it was called the High School of Music and Art, and now it's called the LaGuardia High School. But you took an exam to get in. I passed the exam. I was a pianist and a flutist, and I thought I was a pretty good musician. And so did they at first. But as I spent 4 years there, I noticed a lot of other people in my class who were really a lot better than I was. And I realized that to make music a career, you got to be really at the very top. And if you're not at the very top, you probably will starve. And so I had one music teacher in the school who noticed that I was constantly arguing or debating with the teacher and said, "Oh, someday you're going to be a lawyer and you might be the governor of New York someday." And actually, I sort of tucked that in the back of my brain. And I ended up going into law. Now, when I graduated from law school, I left New York, assuming I'd be back, but I never went back.
Oh, yeah. Okay.
Of going away, getting exposed to the rest of the country, and my time in Texas was very satisfying. And the judge that I worked for encouraged me to go to Washington because she thought the experience would be great. Maybe come back to Texas after a tour of duty in Washington. Remember, those were the days that Lyndon Johnson was in the White House. So coming from Texas was probably a good thing. And a lot of the people who I dealt with at the Justice Department just assumed I was a Texan without the accent.
All right. So did you ever beat LBJ?
Yes.
Okay.
So met President Kennedy.
Really?
Yeah.
Wow. That is amazing. So what initially drew you to environmental law?
It was an accident, much like going into antitrust. It just happens, and you have to make a decision. Is this an opportunity? Are you willing to try it? It may not have been my first choice, but I moved into environmental law in 1979, I would say. And the antitrust business was on the decline. Jimmy Carter was president at the time, and my sense was that he didn't care much about antitrust. So the Justice Department wasn't bringing a lot of cases. And the kind of work that I was doing was largely with regulated industries. A lot of my work was actually before the FCC, the Federal Communications Commission. So my principal clients during the 1970s was Western Union Telegraph Company, which was facing new competition. And the issue was, is the Western Union Telegraph Company going to fight it or support it? And for a while they were fighting it, so that was my job.
Okay. So what motivated you to move from the DOJ to the private sector?
Well, after you spend about 3 or 4 years in government, you have to make a decision. Do you want to make government your career, or do you want to go into private law practice? And most people make the choice to, at least in those days, go into private law practice. The great benefit of the government service early in your career is terrific training. You get exposed to very challenging assignments. Literally on the day I arrived at the Justice Department in September of 1966, I was assigned to the biggest merger case in American history at the time.
What was that?
The Penn Central Railroad merger, the Northeast. And a week later, I was in court arguing some procedural motions before a 3-judge panel in New York City, in the Southern District of New York. And within a couple of weeks, I had won my first court appearance. No beginning lawyer in private practice ever gets that kind of experience. So to me, government exposure is really wonderful experience. The government treated me very well. Within a few weeks after my arrival, they detailed me over to the U.S. Attorney's Office in Washington, D.C. to help that office out with criminal appeals. Now, these were ordinary criminal appeals in the federal court in Washington, D.C. that the government had won at trial. And remember, I had been assigned to the appellate section of the antitrust division. So most of my work was not appearing before a jury. In fact, I've never been in front of a jury. But I've done dozens of appeals in appellate courts or motions practice in trial courts. And I was assigned for a 14-week stint in the U.S. Attorney's Office, and they assigned me to 6 cases to defend the government's win. And in one of the cases, and I tell this story to all beginning lawyers, I got assigned to what was called a dog, a hopeless case. There is no way you can win it. The trial judge had made a mistake that was so obvious from the materials that were given to me that a responsible lawyer would recommend to the superiors. And remember, I'm a beginning lawyer. I'm probably a lawyer for 2 months at that point. And I said, this case can't be won. The trial judge made an error that he had previously made and gotten reversed for doing it. He did the same thing a second time. And so there is no argument you can make to defend it. And I was told, do the best you can. So they wouldn't let me confess error. As a result, I appeared in court. I noticed when I arrived there that the public section was full of assistant U.S. attorneys who knew from the grapevine that this day would be one when there would be fireworks in the courtroom. The judges will be livid at the government, and I'm the government on that day.
Mm-hmm.
And it turned out in those days, we didn't know which judges we would draw. So when you walked into the courtroom and you saw the names of the judges on the bench before they show up, I knew I had drawn the judge who had reversed this trial judge previously. So I got the same judge who had already decided this issue. So I had such an angry court that I was never able to get the words out, "May it please the court," which is how every lawyer starts an argument. They started bombarding me with questions. The courtroom was full of assistant U.S. attorneys, as though I was in the Colosseum with the Roman legions and the lions were going to attack me. And at the end of 20 minutes, I was still standing. And of course, I lost the case, as I should. And many years later, I ran into that judge on a social occasion, and I went up to him and I said, Judge, I just wanted to thank you for something you did for me that you don't know you did for me. After having gotten through the 20 minutes of your anger and your colleagues on the panel being angry and rightfully angry, I knew that I could survive anything because nothing could be worse than this experience. So after that, I knew there's no case that could ever be worse than that. And I got that experience 3 months as a lawyer. So I tell beginning lawyers that story because to get an assignment like that and to survive it tells you can handle anything that can be thrown at you.
Yeah. So why do you think, did they give you that because you were because you were the new guy, or was there other reasons?
Oh, I have no doubt that nobody in that office wanted that case. And so here they had somebody who was visiting. I was a visiting lawyer. I wasn't going to be staying there. I was going back to my job in the antitrust division. Give him the dog.
And that's what they call the dog is, hey, they give him the job nobody wants.
Yeah.
Yeah. Wow. So what was the most challenging or rewarding case you ever worked on?
That's a very good question. I've had absolutely fascinating cases. Well, I've had all kinds of cases because when I went into private practice in the 70s, I was at a Washington, D.C. firm called Wald Hartgrader and Ross. That firm no longer exists, but it was a very up-and-coming firm. I was the 9th lawyer they hired. The firm went up to about 100 over a dozen years, and then it began to decline for various economic reasons. And I started doing environmental work there because the antitrust work and the regulated industries work at the FCC was in decline. And so I needed something else to keep me busy. And we had acquired a new trade association client dealing with the Resource Conservation and Recovery Act. And the EPA at the time had just published a new set of regulations under the statutes. The nickname is called RFRA. I'm sure you all know that.
Yeah.
And they needed an appellate lawyer to review it and see whether there are any issues that we should be litigating. And so the person who managed that client came to me and said, "Would you be willing to handle an environmental appeal?" I said, "Sure." And I quickly figured out that it's no different than suddenly handling an antitrust case in a different industry. You have to learn the market. You have to, in other words, I had become an expert in railroad mergers. I had become an expert in telecommunications issues that are regulated by a federal agency, the FCC, and the procedures in court are really no different. So it was an easy transition into environmental appellate law. And we have a statute called the Administrative Procedure Act, which sort of governs the procedures of dealing with regulated industries and how you appeal their final actions to appellate courts. So that I already knew. So it was actually an easy transition. So a lot of people are always surprised when I say it wasn't a big deal to go from antitrust to environmental law.
So in that situation was your first exposure to environmental?
Yes.
And so because of that, you decided to continue practicing in environmental, or was there other
No,
reasons?
when you start in it and more comes your way, you just do it.
Okay.
If you're enjoying it, why would you say, no, I don't want to do
Right.
that anymore? Now, I continue to do some telecommunications cases. I did some work after the breakup of AT&T, the Bell system. I handled it
Were you
for.
part of that? Or did you work on that?
No, I didn't work on that case, but in the aftermath, I was asked by what was then called Bell Atlantic, which represented the Northeast, to handle a claim they had against AT&T over a money dispute. And that had been tried at the FCC. I had nothing to do with the FCC proceeding, but Bell Atlantic wanted to appeal it to the Court of Appeals, and I was asked to handle it, and I won it for them.
Oh, good. Well, good. So you were talking, so it sounds like you got an environmental because people just would bring it to you going, hey, he has experience in it.
Well, that's what litigators do. If you
Yeah.
think about who does litigation, you are not the substantive expert. You have to learn that. But you are the expert in how to handle the proceedings in court, whether it's at a trial as a jury lawyer or as an appellate lawyer
Okay.
or in the Supreme Court.
Well, I was also reading you were also admitted to the bar of the Supreme Court of the United States.
Yes.
What does that mean?
Well, I don't want to overstate that. Lots of people are admitted to the bar of the Supreme Court. It's a nice certificate. And my membership was sponsored by the Attorney General of the United States in the Johnson administration, who was, by the way, a Texan named Ramsey Clark.
Okay.
And I've actually never argued a case, but I've handled a lot of cases in the Supreme Court. I did one while I was still in the government. There were several, actually. The Penn Central merger case ultimately did go to the Supreme Court. I had participated in the brief writing, but the higher ups get to argue cases in the Supreme Court. And I had one, let's see, under something, there was some foreign trade case that I handled the brief. And the Supreme Court took the case for argument, and Warren Christopher, who was then the Deputy Attorney General of the United States, argued it, and I spent a week preparing him for that argument and sat next to him at the bench in the Supreme Court. He went on to become Secretary of State under Bill Clinton, I think it was. I had, let's see, any other interesting? Well, one of the most fascinating cases was my last case in the Supreme Court. It was a pro bono case in which the firm's pro bono administrators said, we've been asked by the NAACP if we would case involving a form of affirmative action. And there had been 3 lower court cases. One was out of New England in what was the First Circuit. There was one out of Louisville in the Sixth Circuit, and then there was one out of Seattle in the Ninth Circuit. And what the NAACP wanted to do was to file what is called an amicus brief. So we're not a party, but we file a brief to encourage the Supreme Court to decide the way who you're representing would like the case to come out. And you can often provide a lot of background of what the implications are of going one way as opposed to the other. Now, what's interesting about that case is that this was around the time that Chief Justice Rehnquist died. So there was a turnover in the Supreme Court. And Justice Sandra Day O'Connor had already announced her retirement. So you were going to end up with 2 vacancies on the Supreme Court. Well, while she was still on the court, the case coming up from the First Circuit in Massachusetts was before the court, and the Supreme Court rejected that case, decided not to hear it. But the Louisville and Seattle cases were not as far as advanced. And so they came up after the turnover in the Supreme Court. So Rehnquist is gone. O'Connor is gone. Roberts is now the Chief Justice. And Alito is the new replacement for O'Connor's seat. And this new alignment grants certiorari, which is the legal term of art, meaning we'll hear the case, or these 2 cases. So Louisville and Seattle will now be heard. And the way we were asked to brief this is they asked me to line up a group of members of Congress to be the named parties in this amicus brief. Amicus means friend of the court, by the way.
Okay.
We're not a party. We're just a friend of the court. And so what I did was, I have to add one other element here. The firm that I was with at the time, Piper and Marbury, had as one of he was not a partner because he was not a lawyer, but we also hired people who were expert in fields like economists or lobbyists. But this fellow was the former House Majority Leader, Dick Armey, who you may remember. He was from North Texas.
Yeah. And
it turned out his office was next to mine. And so we became somewhat friendly, and they asked me if I could approach him to ask him to help line up some members of Congress to be named parties on this brief. So he said, sure, I'll call John Boehner, who was then the majority leader.
Mm-hmm.
I mean, I can't call John Boehner, but he can call John Boehner. And so John Boehner said to him, have your guy call the guy who was chairman of the Education Committee, the Education and Workforce Committee. And so so basically, Army greased the skids for me by calling this chairman first. And the chairman said, okay, I will tell the staff to take his call. So I called them and set up an appointment and came down to meet with them. And I told the story of what we were going to argue. And my strategy was to show that what we were asking the school boards in Seattle and Louisville to do is what the courts had been doing for years to make sure that you didn't have de facto segregation in all these school districts. And the other thing that I also wanted to do was to go back into the history of trying to make sure that there is no isolated minority, so that the minority is just one or two people in a school where they're just overwhelmed. And that policy to make sure there is no isolated minority started with Richard Nixon in the 1970s. So I was able to find the documents that established that policy in the Nixon administration. So I was trying to appeal to conservative justices to say, this is nothing new. What we're asking for is what you've been doing for 30 years, 40 years, however number of years this was. And so but I also wanted the member of the House from Seattle and Louisville to be the first names on the brief. And so I called them. The Seattle congressman was a Democrat. The Louisville congresswoman was a Republican. And he agreed. She refused. The staff director of the committee told me that what I was arguing are positions that Republicans in Congress have been taking for years. But then he said, I don't think you're going to get anyone on the Republican side to support you, because the Bush administration has now come out against your position in the Supreme Court case. So nobody will want it. And of course, this was in election years, 2006.
Okay.
They said to me, the subcommittee chair is the only one who might support you, but he had recently had a stroke and he may be hard to reach. And in fact, I never was able to reach him. He was a Delaware congressman. So I basically had no Republicans on my brief, but I had 40 Democrats. And I would tell the NAACP that it's not going to make any difference. They in this Supreme Court, having 40 Democrats means absolutely nothing. So filed our brief. I knew I had 4 votes. I didn't know whether I had 5, and you need 5 to win.
Okay.
So I went to the oral argument, and at the end of the oral argument, I knew I was going to lose. I had my 4 votes, and when the case finally got decided months later, it was 5-4 with the Chief Justice writing the opinion, and dissents, pretty angry dissents from Justice Breyer, Justice Stevens. I forget whether there were any other dissents, but Breyer, who delivered his dissent orally from the bench, which is not common. The dissents usually are just, you leave it to the writing. Okay. But feel passionately about it, you have the right to summarize your dissent in public. And Breyer began by saying, this dissent is double the longest dissent I've ever written. And he went through in great detail why the majority he felt was wrong. So, but 5 counts.
Yeah.
5. And
so you had mentioned that you said after the oral that you were going to lose. You know why? Why was it?
Or the kinds of questions that were asked to the lawyers. The amicus didn't get to argue,
Okay.
but I could tell from the questions that there were 5 justices who disagreed with what I was arguing.
Okay. Wow. I tell you what, it's only been a big part of history there. With
Yeah.
all the, yeah. So kind of shift gears, and how did you get involved with ASTM?
That's an interesting story as well. I guess I joined ASTM in 1996 at the request of one of my clients. Again, it's this utility industry trade association that I had now been working for since 1979, and to a segment of that association, the big issue was the regulatory status of coal ash. And I'd been working on that issue really going back to 1980. And one of the issues was involving coal ash was the policies regarding the recycling of coal ash. Coal ash is something that can be used in other contexts. A couple of good examples is in cement and concrete.
Mm-hmm.
Another one is in highways, roads. The runways at LAX in Los Angeles and in Newark Airport are coal ash. So the RCRA statute has provisions in it that instructs EPA to promote the recycling of resource materials. And so their first actions were on coal ash. So EPA has been very supportive of recycling of coal ash. ASTM was developing standards on recycling of coal ash. So the committee at the trade association that's responsible for coal ash regulatory policy said we ought to get involved with what ASTM is doing here because that's going to affect the marketability of coal ash. So that's how I started at ASTM E50 committee.
Okay.
The leadership included somebody who had worked for EPRI, which is the Electric Power Research Institute, which is the research and development arm of the electric utility industry. So at that time, that was Gwen Eklund. And I had actually known Gwen from some other issues years before. So she was very gracious and kept promoting me to take on more of a leadership role in ASTM. By 1998, somebody suggested I ought to become a member of the executive subcommittee. And so they nominated me to be recording secretary, which is the one job that really has a lot of work associated.
Mm-hmm. Yeah, you need to know how, if you're going to go on a board position, you need to know which position to pick. Like at large is.
Well, if you have the opportunity to pick, nobody gave me that opportunity. So I came on, and I've been a member of the board ever since.
Okay.
Yeah, that is going to come to an end this year. I've decided. I'm currently the second vice chair of E50, and I would be up for re-election this fall, but I'm not going to run again. So there comes a time to say I've done this long enough.
Mm-hmm.
I rotated in a lot of the positions. The only 2 positions I've never held are either membership secretary or chair.
Right.
And I have a view that to be an effective chair, you really have to have a lot of technical expertise. And I don't really have that. I am really just a lawyer.
Right.
I learn what I need to learn, but we've had excellent chairs, and I've never felt that I could do a better job than the people who've been chairs. So I've never sought the office.
Yeah, no, we've been lucky. ASTM's been lucky. You're right. They've had excellent chairs, but it is important to have attorneys present or be a part of it because, just seeing, going through the 1527 and 1528, I know you led that effort. Was it with Georgina? Did you guys do that together?
And Walker before her.
Yeah, that's right. With John Walker. Yeah. And it's definitely helpful because, it's interesting when you're sitting there, you're getting into, should we use the word shall or should or likely or whatever it is? And I don't know. I guess I'm sure they were attorneys involved in the very beginning, but it seems that even more so now. I mean, with yourself, Larry Snaff, Jim Barta. Is Jim Barta attorney? Or no, he's not. Not.
No.
Tim is though, right?
Yes.
Okay. Yeah. And so it's just, I don't know, I just know sitting in there that, over which word should be used or whatever, or there's always an argument you didn't think of. And so anyway, but now how'd you get involved with Julie Kilgore?
There is a story there. Remember, Congress passed an amendment to CERCLA, Superfund statute in 2002. And that was a fairly broad revision to deal with a lot of issues that had crept up from what you might call the first generation of Superfund. Things that were unanticipated, that complicated cleanups. And so Congress passed this statute in 2002. And one of the assignments was to develop a regulation that dealt with due diligence in property acquisitions. Mm-hmm. Essentially what E1527 and 1528 deal with. And the statute that Congress passed had 10 criteria that the EPA should take into account in developing this regulation. So EPA made a preliminary decision to try to do a regulatory negotiation. Now, EPA has had a history of trying regulatory negotiations up till that time and had never succeeded. The combat positions of the various stakeholders in these negotiations, from environmental groups to industry to civic groups, have been very hard to reconcile. These groups don't have the ASTM custom of trying to develop consensus. So consensus is not one of their goals. But EPA decided they were going to try it again and thought maybe this rule might work. Now, my clients at that point were telling me, well, we like the ASTM E1527. So is there any way of getting the regulation that EPA is developing to be as close to 1527 as these 10 requirements would allow? And I said, well, we can certainly look into that. I mean, that can be a goal of the rulemaking. Well, I get a call from a consultant to EPA saying they'd like to come over and talk to me about this regulatory negotiation. So I met with them, and they asked me what I thought of the regneg. It's called a regneg for short. And I said, well, you don't have a good history of doing this, but I don't see any harm in trying. And so the conversation went on, and then they finally asked me if I'd be interested in being on the regneg. And I said, I can do you one better. I can recommend the person who's already been through all of this at ASTM. And you could benefit from having that person's experience in dealing with all of these issues. Now, I had never done a due diligence at that point in my career. So I felt Julie was infinitely more qualified to achieve the goal that my clients had asked for. And there was no doubt in my mind that her interest would be to try to get EPA to come as close to the ASTM standard as is possible. So I recommended Julie to them, gave them the information that they could contact her. And then I called Julie to warn her that she may get approached about this. And I said to her, Julie, you're going to be the most qualified person in the room if they offer you this position. You should take it. And she says, but I don't know anything about politics. And I says, you don't need to know about politics. You just are going to know more than anyone else there. You've had the experience. Now, what I predict will happen is at the first meeting, there are going to be 25 people, these various stakeholders, there are 25 of them, and there are going to be a bunch of EPA people in the room too. And the stakeholders are going to know you're smarter than they are. And they're going to want to beat you up that first day. And don't worry about it. Just sit there and take it. Don't let it bother you. Just ignore it. At the second meeting, when they start getting into issues, let them debate. And they're going to get to an impasse, just the way we did in E50. And at some point, somebody's going to say, hey, Julie, how did you all resolve this issue? And bingo, you're now in charge for the rest of this negotiation. And that's exactly the way it happened. And so she was the most qualified person to help them through this thorny process of resolving all the issues that ASTM has already dealt with. And EPA was very grateful for having her. The EPA person in charge of this rulemaking, Patricia Overmeyer, and Julie became very close because they really supported each other.
Yeah. Yeah, those two women did an excellent job. I remember you referring to AAI, right? Okay. So I remember that came out. That was a huge
all appropriating
inquiry. Yeah.
And EPA adopted the rule, I think, in 2005. It's never been amended since 2005. So it's still there in the form that the regulatory negotiation and EPA went forward with it. So, now Patricia just retired from EPA, and I was invited to her retirement party. And Julie gave me a statement to read on her behalf to say how much Julie and the rest of us at ASTM have appreciated working with Patricia. I mean, Patricia has been a very sensible leader of this effort. She's really smart.
She has. Who's taken over her position over there now?
They've assigned somebody whom I've only briefly met once, and he was not at the most recent meeting. So I don't recall his name, but there is somebody who's been assigned.
Okay. Well, did I read that? And I'm not sure. I was looking at your timeline. Did you retire in 2012?
Yes.
I did not know that. This whole time, I thought you've been working.
Oh, no. I retired from the law firm. Remember, I was no kid at that point. I was one of the oldest lawyers in the firm.
Oh, my gosh. I'm trying to think of when we first met, but this whole time, other than here, I thought maybe a year or two ago, maybe you retired. This whole time, you've been retired because I would see you at ASTM meetings. You're constantly working.
You're tired. I mean, what people told me before I retired is why you will discover that after you retire, you will be busier than ever. And I could never believe that because I couldn't imagine what I'd be doing. But in fact, I have been busier than ever. Uh, After I retired from the law firm, I had a goal of something I wanted to do that I never had time to do while I was busy in the law firm, and that is to write a scholarly law review article. And I already knew what I wanted to write on because it was an issue that I had worked on at ASTM, and that is the what is called the continuing obligation standard.
Right.
And that is the standard that deals with what happens under the 2002 amendments after you've acquired this property. You've done all the things that you're required to do for due diligence. You now have closed the deal. Now, what do you have to do? Well, that's what continuing obligations is all about. But one of the things that my colleague at ASTM, Mike Sawinski, I discovered and then he is also a lawyer, by the way.
Yeah. Yeah, no, Mike.
In working on the standard, had several issues on which we disagreed with EPA. And we also disagreed with some post-2002 court decisions. And so we had identified 4 issues in which we thought the decision makers were getting it wrong, did not get what the Congress was trying to do.
Mm-hmm.
And we also quickly realized that the ASTM process does not lend itself to resolving those issues. EPA can never change its position on an issue at an ASTM meeting. It just isn't going to happen. So EPA wasn't going to agree with us and agree on a consensus on those 2 issues. And as to the courts, some courts agreed with us, other courts didn't agree with us. And we thought the best thing we could do is lay out these issues and explain our reasoning in a scholarly piece. Well, that's a very time-consuming process. So after I retired, Mike and I decided we were going to jointly write this article. And the more we wrote, the longer it got. And it took us over more than 2 years to write it. It was when it was finally published, and it was published by the University of Virginia Environmental Law Journal in 2015. We got a lot of praise for having laid out these issues. The greatest satisfaction we got out of that is EPA has since changed its position on both of the issues that we criticized them on. They are now agreed with what we said. And so that, we helped to change the legal interpretation of the regulatory agency. And they did it in the way you normally do. They had a public comment period. And they ultimately came out with a revised interpretation of the 2002 amendments that we think are now correct. The courts is a little different. Some courts are not with us, others are with us, and time will tell what happens. I'm not sure these issues will ever get to the Supreme Court. Ultimately, these kinds of differences of opinion on the law go to the Supreme Court for resolution, but I don't see anything like that working its way up to the Supreme Court now.
That was a big part of the latest changes in 1527 were related to land title records, activity use limitations and so forth like that. So, because that was being misinterpreted earlier, even though I thought it was clearly laid out in the previous standards of 1527, but people were we're in it. We're definitely, I guess, not interpreting the definition. It referred to currently impacting the property or something like that, and they were totally, define that something else. So I guess Mike went through, and because I identified it to Julie, like, we have an issue here. And then Mike got involved and, really looked at that section of the land title documents and, to try to clear that up. And that's all related to what y'all did, the continuing obligations,
Well,
to identify those.
I mean, that is the process.
Yeah.
If you disagree with the then prevailing interpretation by the regulator, you write it up. You see if you can get it published. We were lucky. The University of Virginia Environmental Law Journal was very interested in having our article. We violated their rule on length by a lot. One law journal had offered to publish it in 2 parts. We ended up, when UVA agreed to publish it in 1 part, of course, we said, fine, we'll go with you. And they did very little revising. A publisher does what they need to do. We had a wonderful relationship with the excuse me, the students who run the Environmental Law Journal at UVA in 2015. So it was a wonderful experience. It was something I've been wanting to do throughout my legal career, but it takes so much time that if you're a busy lawyer, you don't have time to do that.
Right. Well, hey, look, like I said, it had, I think it was a significant piece you guys did, because obviously it, still impacts everybody now. So, hey, glad you guys did it. So you've been retired since 2012. But you're still working. I know you're doing writing, commentary. You're an expert witness, so forth like that. What about, are you traveling at all?
Yes.
Yeah.
I'm heading to Africa next month.
Okay.
I'm going to South Africa for just under 3 weeks. I'm going to be touring. I'm going to Johannesburg. I'm going to Kruger National Park in northeastern South Africa. I'm going to a private game reserve in the northern part of South Africa. Then I'm going into Zimbabwe to Victoria Falls and seeing this wonder of the world. And we'll be there for, I believe, 4 days. Hope there's plenty of water on the falls, that you're taking your chances. You don't know. I think we're in the right time of year to have plentiful water going over the falls. And then we go to Cape Town and spend maybe a week in the Cape Town area, drinking wine, visiting Robben Island, climbing the Cape Mountain in the city, and going to the Cape of Good Hope. So I think it's going to be a very exciting trip. I'm traveling with one of my sons and my daughter.
Oh, it's going to be fun.
It's going to be very exciting for all of us. But 5 years ago, let's see, 2019, well, it's almost 6, I guess. I went with one of my other sons to Vietnam.
Oh, how's that?
Traveled throughout Vietnam. He and I split up at the end of the trip because I wanted him to go to Cambodia, but I'd already been there with my wife about 20 years earlier. But I said, Angkor Wat is a don't miss. I mean, you're close enough that you'd be insane not to go there. But since I'd already been there, I wanted to go someplace that I hadn't been to. So I went to the ancient royal capital of Laos, Luang Prabang, which was also absolutely fascinating place to visit. But I've traveled all over Asia, and I've traveled everywhere. I've been in the continent except Antarctica.
Is that one of your goals?
I'd love to go to Antarctica. At my age, I don't know if they'll take me, but who knows? I still have places I want to go to. I've not been to, so I would still do that.
In previous conversation, you told me you spent a lot of time in Santa Fe. Is that a place?
I have a summer home in Santa Fe, New Mexico.
Okay.
I've had it now since 2011. Uh, my wife and I picked Santa Fe for a couple of reasons. One, she hated the summers in Northern Virginia in the Mid-Atlantic, where it's very humid.
Mm-hmm.
And so she wanted to find a place that we could go to. And both of us had often traveled to Santa Fe in our younger days. I would go there to go to the opera. They have a summer opera company that's really world class, and love that. She would go. She said she had been going there since she was 8 years old with her aunt, who was a dealer in Indian art. The aunt was a dealer in Los Angeles, and every summer she would go to drive from LA to New Mexico, stopping at the Pueblos and buying her inventory for the coming year. And she'd get there in time for Indian Market, which is an annual event of the third weekend of August in Santa Fe. It's the biggest Indian market in the world. And it's a juried competition. So the only requirements is the jury has to approve of the quality of your art. And two, you have to be a Native American or native first citizen, I guess is what the Canadians call them. And I believe this year will be the 101st year of the Indian market. And it's a fabulous market. We've bought stuff at the market. My wife knew what she was buying. This is not her expertise. This is hers. Sadly, she's no longer with us. She passed away in 2017, but I have continued to go out there. I've made friends in Santa Fe. I still love the opera. And I'm going back in mid-June, and I will be there all summer. I have discovered that my friends like to visit me in Santa Fe. They don't come to Northern Virginia. So this is a way of seeing friends from all over the country. And my friendships are really all over the country because my work took me all over the country.
Yeah,
we've been in 50 states.
Yeah. Wow. Well, that's what it is. You're right. Like we do make a lot of friends all over the country because people we work with, or just either with ASTM or other organizations, been fantastic. And I've learned a lot from people in the industry. And they're very giving. They're very helpful. They want to help that next step. So yeah, there's a lot of great people.
One of the great things you learn in the ASTM process, to build a consensus, because that's the name of the game.
Mm-hmm.
You have to learn how to listen.
Yeah.
And I keep trying to tell people the most important thing you do at one of these meetings is just sit there and listen to what people say and watch the body language.
So would that be the advice you'd give the next generation?
Oh, absolutely.
Yeah.
Absolutely. I've never been a fan of video meetings.
Yeah.
When I was going to meet with EPA to negotiate something, I want to be in the room because it's not only the words that are said, but the body language that I will follow. And I want to see how one EPA person reacts to something some other EPA person says.
Mm-hmm.
You get to figure out who might be your friends in the room.
Yeah. Yeah, a lot of that changed since COVID, and you're absolutely right. I prefer, I would love to do these podcasts in person. I think it would be fantastic to sit down with yourself and other people and just have that conversation in person. There's nothing beats it. It's funny because a lot of people will text today. I
Yeah,
prefer a phone call.
me
I mean,
too.
pick up the call, pick up the phone,
I'm
call
not
me.
a big fan of texting either. And the big problem I have is my phone gives me a little beep,
Hmm.
and it's the same beep when newspapers send out their little bulletins. And so I get too many of those. So I often don't get up and look every time it beeps. Uh, and so sometimes I take a long time to answer, and I don't mean to be rude, but that's what sometimes happens. So I'm not a big fan of texting. My kids are all texting, my grandkids are all texting. So I simply conform.
Yeah.
You do it because the people you care about do that. Um, but it's the way it is. But if you're dealing with some serious issues like negotiation or drafting a STM standard, you really belong in the room.
Yeah. Yeah. You can't replace that in-person
And
meeting.
one of the things, I don't know if you were in the room when I announced at the 1528 meeting just 2 weeks ago that I was planning to retire at the end of the year, and I'm giving up the co-chair position. I said my greatest pride in that work in 1528 is that I've never had to take any dissenter to a ballot to get them overruled through the balloting process. I've been able to work out every difference of opinion with some kind of compromise that everybody involved could find acceptable. To me, that is a matter of great pride.
Yeah. That's a big accomplishment because I think with the other standards, I don't know if that's happened or not, but I know with 1527, it
It
didn't.
hasn't been possible in 1527, as you probably know, that we had a real battle over the assumption of risk-based cleanups in 1527. And we developed this concept of the CREC, the I'm not sure I remember that you use CREC so often. Um, uh, that takes into account a standard that's acceptable to a regulatory authority, but it isn't the removal of the last molecule of contamination.
Mhm.
And EPA supported us when we did that. But we had a big fight with some people on our task group, and Julie had to take that to a ballot to find them not persuasive.
Yeah. I
Um,
remember that. It was, I know she was going through a lot back then trying to get that
I
passed.
never quite understood why they adhered to the position they took. I always thought that the position we were advocating with EPA support made a lot of sense, and it would promote more cleanups. And
Right.
to me, the goal is to clean up sites.
Yeah. I don't know if maybe they had a client that didn't like that position. I'm not sure because I heard that, but I don't know. That's all
Sure, I
hearsay.
understand it, but almost all of the people who took that position were lawyers who were active in the ABA section on environmental law, and I'm not sure I understand that. Some of these people whom I worked with in the past, I like them. We just disagreed on that,
Yeah.
and I struck out. I could not persuade them about the merits of the position. So ultimately, Julie had to go to ballot.
Yeah. Well, it sounds like you got some things coming up here soon, some traveling. So that's exciting for you. I can't wait to hear about your trip to Africa when you get back.
Well,
And so,
to go because I have probably only a week between returning and then heading out there.
yeah,
My visitor is coming in right after the middle of June, so I got to get out there and clean the house because it accumulates a lot of dust in the winter. We're in the middle of a desert, remember?
right. Yeah. Oh, it's beautiful. Santa Fe is beautiful. And maybe, I've gone out there a few times and
Well, be sure to let me know when you come.
I will. Well, Bill, I appreciate it. It was fantastic to sit down with you and hear your story, and I appreciate it. And I look forward to next time. Again, thank you for coming.
It's a pleasure.
Yeah. All right. Thanks
Take
again,
care.
Ben. You bet.